Imagine being a victim of modern slavery or human trafficking, forced into committing a crime, and then you're the one facing prosecution. I'm Dr. Alicia Hayes, a senior lecturer in modern slavery at the Wilberforce Institute, which is based at the University of Hull.
And I'm Dr. Grant Barclay. I'm an early career fellow in evidence and criminal law at the University of Edinburgh.
Today we're looking at this issue, where victims of modern slavery and human trafficking commit crimes as part of their experience of exploitation, and we're considering the different approaches between Scotland versus England and Wales to this issue. Grant, can you tell us about this terminology of modern slavery and human trafficking?
Yes, I can. So when we talk about trafficking in persons, there are various definitions, official definitions that you can look to, but generally speaking we're talking about recruiting or transporting people through means of threats or use of force or other forms of coercion or abduction in order to force them into situations where they are exploited. The exploitation can take various forms. Sexual exploitation for one, forced labour, servitude, and so in the UK different terminology can be used to describe this. So Scotland sticks with terminology of human trafficking and exploitation, but England and Wales has moved towards using modern slavery as this sort of overarching concept that refers to trafficking. So we'll, in this podcast, probably refer to modern slavery and human trafficking and exploitation interchangeably, but that's just to give some background as to the official sort of terminology that's used in these jurisdictions.
And today we're focusing on criminal exploitation as one of those forms of exploitation that can occur among victims of modern slavery or human trafficking. And criminal exploitation is essentially where a person is recruited for the purpose of committing criminal offences for the benefit of their perpetrator.
Exactly, and I think a really obvious example that we often see would be in relation to sort of involved in the production of drugs. So cannabis, for example, cannabis farms, people being forced into the country, and then they would have to look after cannabis farms, and they perhaps then get the operation is discovered by the police. And it would not only be the traffickers, and in fact sometimes the traffickers are nowhere to be seen at this point. It will be the people who've been looking after the farm that are then subject to criminalisation. They're subject to criminal liability.
So to provide a bit of context as to where these issues arise from, can you tell us about the international obligations for states around protecting victims who have committed crimes because they're victims of modern slavery or human trafficking? Yeah,
absolutely. So this is an archaic issue. I mean, obviously human trafficking has been going on for millennia, but more recently there are international obligations that obviously have an impact on the legal situation that we have in the UK, both in England and Wales and in Scotland. So I think probably a good place to sort of focus is on the European international instruments here, as they have had a direct influence or impact on the 2015 legislation in the domestic legislation in both Scotland and England and Wales. So we're starting with the Warsaw Convention back in 2005, the more official title being the Council of Europe's Convention on Action Against Trafficking in Human Beings, and this Article 26 imposed an obligation on signatories to provide for the possibility for national authorities not to impose penalties on victims of trafficking or modern slavery for their involvement in unlawful activities, to the extent that they've been compelled to do so, right? And this principle of non-punishment, as it's known, was expanded when the Warsaw Convention was adopted into EU law by the 2011 directive. Article 8 of that directive is in similar terms to the Warsaw Convention, but it's slightly more expansive because it talks about member states being required to take necessary measures to ensure that competent national authorities are entitled not to prosecute or impose penalties on victims of trafficking and modern slavery for their involvement in criminal activity. So it's no longer just about punishment, it's also about criminalisation. And so you can think about it being about non-criminalisation and non-punishment, these sort of dual principles that member states need to adhere to in constructing their own domestic legislation. And so in 2015, we had the introduction of the Modern Slavery Act in England and Wales and the Human Trafficking and Exploitation Scotland Act in Scotland as well. And they introduced, in some ways quite similar, but in other ways quite different measures in order to deal with combating criminal exploitation and giving effect to the non-punishment, the non-criminalisation of victims of trafficking, so those compelled to commit criminal acts as a result of their trafficking experience.
And that's how our work ended up overlapping.
Absolutely.
So Grant and I met at a workshop last year, which was looking at investigating the experiences of people who were both victims and treated as criminals. And I'd recently done some research looking at how the Modern Slavery Act deals with these situations in terms of the criminal justice system treating some people as offenders, but who have only committed those offences because they were victims of modern slavery. So we ended up talking quite in depth about this because I knew quite a lot about the situation in England and Wales, but didn't know the equivalent in Scotland. So Grant and I got talking and ended up applying for some funding from the Scottish Institute for Policing Research to investigate this exact overlap, so looking at the differences between Scotland and England and Wales in their responses to victims who've committed crimes. And we came together at the University of Edinburgh to have a workshop with professionals working in this field, and this brought together a range of different people from England and Wales and from Scotland for us to better understand the differences in responses, but also the differences in what policy says should happen and what is happening in reality on the ground.
So before we get into the nitty-gritty of the discussion at the workshop, I wonder if we should maybe let our listeners know a bit more about the legal frameworks that were introduced in the 2015 Acts in England and Wales and Scotland, and maybe you could go through the English and Welsh position first.
Sure, so in England and Wales, this is covered under Section 45 of the Modern Slavery Act, which is often known as the statutory defence, and this is essentially a part of the legislation that accounts for not prosecuting victims of human trafficking or modern slavery who, if they're an adult, have committed a crime because they were compelled to as part of their modern slavery or human trafficking situation. But for children, the defence is there if they committed a crime as a direct result of their modern slavery or human trafficking. And there's lots of intricate details about how this works and considerations about the practicalities as to how it can apply. But I won't get into those just now, but we'll probably pick up on those a little bit later. But I didn't really know anything about the equivalent in Scotland, and I was actually quite surprised to learn that the Scottish legislation doesn't have a specific non-punishment principle like Section 45 of the Modern Slavery Act.
You're absolutely right, yeah.
Can you tell us a bit more about how that does work then?
Yeah. And it's really interesting what you were saying, just to very briefly pick up on the difference between compulsion and direct consequence, because the international instruments, the directive talks about, the provision applying where someone is compelled as a direct consequence. So we have this interesting, there's, as you say, there's a lot of literature out there, and that's not our purpose for today to get into that, but there's a lot of literature out there discussing the intricacies of these tests. The tests are to some extent similar in Scotland, where there is the major difference is that we don't have a statutory defence. So whereas there's Section 45 in the Modern Slavery Act 2015, in Scotland, under the Human Trafficking and Exploitation Scotland Act 2015, it's Section 8 imposes an obligation on the Lord Advocate as head of prosecution in Scotland to come up with guidelines. They're known as the Lord Advocate's instructions, and they are to be used by prosecutors when making a decision about whether or not to prosecute a person that they have good reason to believe is a victim of trafficking, of human trafficking and exploitation. And so the instructions are available online. Anyone can read them if you Google, because they're constantly being updated, which changes the URL, which is very helpful. But you can look them up online, and they are in broadly similar terms to Section 45,
okay,
in terms of talking about if it's an adult, the test is compulsion, and if it is a child, then it's they just have to have committed the act as a direct consequence. So from that perspective, I think that the two tests are quite similar. And again, we'll get into this in more detail. I think the main points of departure are, one, the point in the process at which this sort of test is being carried out, and the second is that perhaps necessarily as a result of Section 45 of the 2015 Act in England and Wales being a substantive criminal law defence, there is this additional factor of needing to determine whether a reasonable person with the relevant characteristics would have done as the accused person did. And I think that's because the defence is one that is, generally speaking, not always, but generally speaking, will be considered by a jury. And so the reasonable person test, that idea of trying to allow the trier of fact, the fact finder, to be able to relate in some way. But that's something we'll discuss in more detail in due course.
So one of the things that I found quite difficult to get to grips with is this idea of direct consequence. And when I was investigating Section 45, I found reviews of the Modern Slavery Act that said there isn't a definition provided as to what is meant by direct consequence. So where Section 45 says that the defence is available if a child has committed a criminal offence as a direct result of them being a victim, there's no clarity on what is meant by direct consequence, which potentially makes it really broadly applicable. Is it the same in Scotland, or is there a definition?
I would say it's the same in Scotland. I think there is. I think this is a national problem in terms of understanding what these terms mean. At least to my knowledge, the general gist is that a child committing an act as a direct consequence just means that there's some sort of factual nexus between the commission of the act itself and the circumstances of exploitation. But I think there is a sense in which the law has been designed so that it's not just the case that you commit any criminal act and you can point towards being a victim of trafficking in order to evade criminal liability. Okay,
so that's interesting, and I think we could probably go off on a tangent with loads of, well, what if this conversations, but I wanted to bring us back to how the courts determine whether we can apply this defence or not. So talking about a 4-stage test to identify whether it's suitable to bring in a defence or not. Can you tell us about what that test entails?
Sure. So just to clarify, actually what's happening with that 4-stage test, and to be clear, we're talking about England and Wales here because obviously Scotland doesn't have a statutory defence. So in England and Wales, when we're talking about the Crown Prosecution Service, CPS, if they believe that someone might be a victim of modern slavery, they will apply this 4-stage test that you were talking about, and that includes within it determining whether, of course, they think that some sort of modern slavery has in fact taken place. It also consider whether or not there is a Section 45 defence, as you've pointed out. But they'll also consider whether there's perhaps a common law defence, a claim of duress. So for just to be very brief, a claim of duress is where someone there is a coercer who forces a coerced person to commit a criminal act through a threat of death or serious injury that has to be quite immediate. So generally speaking, when we're talking about modern slavery and human trafficking, the chances of there being a duress claim or coercion claim, as it's known in Scotland, are very slim, but it is possible. So CPS will consider whether or not there is a claim of duress, in addition to thinking about whether there's a Section 45 defence. And then finally, the fourth part of that test is deciding whether it's in the public interest to prosecute. So there is quite a robust, on paper, right, quite a robust process that's used by CPS in England and Wales to determine whether or not they should prosecute a potential victim of modern slavery.
Okay, but it sounds like there are situations in which a prosecution might still happen then, even if the Crown Prosecution Service has determined that somebody is a victim and only committed the crime because they were a victim. Is that right?
That is absolutely correct, and that's something that we see in both jurisdictions, despite the fact that they have obviously slightly different processes. In both jurisdictions there is a public interest test. In both jurisdictions there is a determination of whether or not a person is, on balance, can be regarded as a victim of human trafficking, exploitation or modern slavery. And obviously in Scotland they may not be as part of, if we think about the 4-stage test, one of the stages of that test is the section, considering whether or not there's a section 45 defence. As I sort of alluded to earlier, the Lord Advocate's instructions that are required by the Scottish legislation are broadly in similar terms to the section 45 defence. When they talk about if it's an adult there's a compulsion element, and if it's a child it has a direct consequence. So the prosecutors both sides of the border are sort of doing a similar thing when dealing with adults, potential victims of trafficking, modern slavery, and again with children. You could have a situation where victim status is conferred. There is a good chance that this person is a victim of trafficking, modern slavery, and yet the public interest, there is a strong public interest leading towards prosecution. So you can have a situation where the Section 45 defence applies, the equivalent applies in relation to the Lord Advocate's instructions, and yet in both jurisdictions, if there is public interest, they will prosecute.
So what do you mean by the term public interest, for those of us who aren't lawyers?
That is a good question, and that is something that I think something that we'd need to do further research on. In fact, I think there is literature out there talking about public interest, and so it's not. I can't give you a very quick and easy answer as to what public interest actually is. But there are certainly some things we can point towards, and certainly some aspects or elements that were highlighted or raised by participants in the workshop in relation to, I think the most obvious would be the severity of the offence. Okay, so if we are dealing with a murder case, my personal opinion, and based on what I've been told by participants and in other conversations, is that it would be very unlikely that the Section 45, in fact Section 45 wouldn't apply, because of there is a list of exempted offences to which it applies. So
there's almost two things to consider here. One being the public interest. So if the prosecutors think that the offence is serious enough, or that the defendant is dangerous enough, perhaps, that the prosecution should still be pursued, even if it's determined that they're a victim.
Yep.
And then the other point, in Section 45, so in the England and Wales legislation, there is a list of over 100 crimes that a victim isn't able to use the defence for. So these are all the crimes, the more serious offences, so things like you said, like murder, terrorism offences, where it's determined that nobody would commit those offences and it's not suitable to use the defence for those reasons. There was a debate amongst some of the participants about how suitable some of the exclusions were. So some of the crimes that are listed that can't be used for the defence are some of the crimes that we know victims of modern slavery are often forced to commit. So things like recruiting other victims into a modern slavery experience, we know is something that is quite common amongst victims of modern slavery, that they're offered or almost teased with preferable conditions in their exploitation if they recruit more people to be exploited. But because modern slavery is considered such a serious crime, the defence can't be used for those situations. And other things like carrying a firearm, we know is often associated with victims of county lines, so where children and vulnerable young people are used to run drugs.
Yeah. So where, children and vulnerable young persons are used to basically run drug supply to smaller, more rural communities, with production and supply occurring in larger cities. So they use these young people as basically drug mules to run the drugs to these locations. And yeah, you're absolutely right. So there are a plethora of offences which are excluded from the remit of the Section 45 defence under Schedule 4 of the 2015 Act, but for which we know from our experiences, and this is what we were learning from our participants, these are really common offences that victims of trafficking will commit.
So how does it work in Scotland? Is there a list of, considering there's no statutory defence, is there a list of crimes that wouldn't be considered to be pursued if someone is a victim? It's quite confusing because there isn't that piece of legislation. I'm just not sure how it works in practice.
Yeah, well, the short answer is no.
Okay.
I think the cynic and the researcher in me would say, well, it really depends on what the prosecutor, what COPFS, the Crown Office and Procurator Fiscal Service in Scotland, want to prosecute, or in terms of that, it goes back to that elusive public interest sort of test. But generally speaking, again, short answer is no, because there is no legislation, or legislative statutory defence. There is also, as a result, no legislative exceptions or exclusions. And in fact, when we were, I think I can probably quite comfortably say that on the day in our workshop, representatives from COPFS were quite shocked to learn about the English and Welsh position, and for them it was very straightforward. They said, no, we just consider victimhood holistically. If a person is a victim, then they are a victim, and that would apply to all offending. But of course, we come back, and this is where I come to my more cynical sort of approach of, we come back to that public interest test, and well, what if we're dealing with, among other things, a murder, right? Or we're dealing with maybe it don't have to be quite as dramatic as that, but we could talk about they themselves have been recruiting others, or they are in possession of a firearm, and all of a sudden we are dealing with a potentially dangerous individual who is undoubtedly a victim of trafficking. Are they still someone that will elude criminal liability, or are they someone that COPFS thinks the public interest test is met, and we will prosecute this person notwithstanding that they are clearly a victim of trafficking?
So this is really interesting to me, and it is essentially a moral quandary, because there is no set line at which you can say a crime was acceptable because of the conditions, or it wasn't acceptable because of the conditions. And the fact that there's such a difference between England and Wales versus Scotland as two countries that are geographically aligned, and then you have other states, like there's an act in Trinidad and Tobago which says that you're entitled to a defence no matter what the crime. So where England and Wales says you can't use it for murder, that's not necessarily the case in Trinidad and Tobago, and maybe not always the case in Scotland, as you've just discussed. But I wanted to come back to something we talked about very briefly earlier, when you touched upon this idea of the reasonable person test. And this really links into what we're talking about here, in terms of, would a reasonable person commit this offence in the same situation? But can you tell us more about what the reasonable person test is and how it applies in practice? And does it apply in both England and Wales and Scotland? Yes,
so as I discussed earlier, the reasonable person test applies where it historically applies to substantive criminal law defences. That might be, now I can't say for sure why there is no, in fact, reasonable person test in the Scottish approach.
There isn't a reasonable person test?
No, there isn't a reasonable person test. So it is very much just a case of prosecutorial discretion, which is informed by the Lord Advocate's instructions, which must make an assessment on the balance of probabilities as to whether or not the person they're considering for a prosecutorial decision is a victim of trafficking, if they've been compelled, if they're an adult, if it was as a direct consequence if they're a child, and whether there is nevertheless a public interest in prosecuting. That is the extent of the test, so to speak, the assessment that's being made in Scotland. Whereas in England and Wales, because there is a Section 45 defence, now there might be a similar assessment going on in relation to a prosecutorial decision, but if we get to the point where prosecution, if the prosecutors of CPS decide, yes, there is public interest, or we just don't think there is a situation of trafficking here, at that point it becomes a situation where the defence is engaged. And part of the terms of the Section 45 defence are to include for both, and this is quite an interesting aspect, both the adult and child test. So you have for both the compulsion test for adults and the direct consequence test for children, they have this reasonable person test, and that is, whether a person, a reasonable person with relevant characteristics would have done as the accused, the defendant, had done. And that's intuitively, I think that's a really tricky assessment, especially if we're asking members of the public.
Yeah.
So we're asking jury members.
So my brain initially goes to, how can a person who's not experienced this put themselves in the shoes to know if they would have done the same?
Yeah.
Because
they might be able to think, oh, would I have done this, as I am today as a person? But do they really know what it means to be exploited? Do they really understand the types of mental turmoil and mental health issues that arise? This is something that was a key issue that was raised by our participants. They were talking about what we're asking of the jurors perhaps goes beyond. And what is interesting here is that this is not an issue that is unique to modern slavery and human trafficking. Okay, the reasonable person test exists for, I would hazard to say, nearly all, if not all, substantive criminal law defences in Anglo-American jurisdictions. So I'm not just talking about England and Wales here, I'm talking about Scotland, I'm talking about in the US, Canada, etc. It is the gold standard, if you like, or just the usual standard, if not the gold standard, because there's a lot of criticisms about how do you get a jury, a lay person to come in and think like the accused, think like the defendant. So it is an issue that it's of general application, but I think it's particularly pronounced in these very specialist circumstances when we're dealing with modern slavery and human trafficking is the obvious example for our purposes. But if you also think about domestic abuse scenarios as well, if we're talking about the use of potentially self-defence in those circumstances and whether it was reasonable to use self-defence. So there are a number of scenarios in the criminal law where we're finding that the reasonable person test is perhaps not quite fit for purpose. And there is perhaps this expectation that because we've used it in the past and it's kind of worked in the past, it can kind of work here, and that's potentially good enough. And
but it's asking a lot of a jury to put themselves in those shoes.
Absolutely it is.
And then coming back to the way that victims are identified. So in both England and Wales and in Scotland, we have the National Referral Mechanism, or the NRM, which is the government system for identifying and referring to support anyone who is a victim or a potential victim of modern slavery or human trafficking. And there's a two-stage decision made for the NRM, and these are reasonable grounds decisions, which essentially say that the person who's referred them thinks that they might be a victim. And then this goes on to a conclusive grounds decision that it's believed on the balance of probabilities that the person is a victim. But what relevance does that conclusive grounds decision have for the application of a defence?
I'm glad you brought this up, because this was something I was thinking about in that last discussion that we had about how the Scottish and English and Welsh positions differ and how they operate. I think an important aspect that we've kind of glossed over or missed up until this point is the fact that when either jurisdiction is making a prosecutorial decision, they must wait for the conclusive grounds decision.
Okay, they have to wait.
Yeah, they have to wait. They must wait. That's what we've been told.
Okay.
That's what we've been told. So this is where I think there is another point of interest that it's worth highlighting here, is that both CPS and COPFS have told us that the position is crystal clear, and there was no disagreement here.
Yeah.
That is, you need to wait for a conclusive grounds decision, and as a result, in terms of the process and practice, I wouldn't say there are workarounds, but COPFS in Scotland, for example, told us that depending on the type of procedure used, they might have to introduce or start a prosecution in layman's terms, but then immediately adjourn the prosecution
while they wait for
that.
Okay.
Because there are time limitations on when they can bring a prosecution. So
sometimes the decisions take a really long time.
Sometimes I
Okay.
think we can. I think the standard waiting time is over a year.
Yeah.
Yeah, it's very long for a conclusive grounds decision.
Gosh, and that must be so stressful if you're a victim who's a defendant and waiting to find out if you're going to be prosecuted.
Absolutely it is. I mean, if you think about the headaches for that are involved in waiting for these decisions for the institutional actors, and then times that by 1,000 if you're an actual victim who's sitting there going through that process and the object of that process. So it's really, really problematic, and there have been delays linked to the reasonable grounds decisions, that first decision as well. Although we were told by participants that there have been there seem to have been moves made or steps taken to try and reduce the times, which is vital. I think that is a vital part of all of this, because the criminal justice process is invariably, it will always be slow. There are so many moving parts, having to wait for witnesses, having to wait for motions to be filed, for evidence to become available. So anything you can do to minimise those delays is really, really important.
Okay, so what happens then if the CG decision comes back and it says, yes, we believe that this person is a victim? Is that just the end then? There'll be no prosecution?
So this is potentially, before we move on, actually, I want to say something very quickly about the fact that there was maybe a little bit of pushback from participants about this idea that prosecution hinges on the conclusive grounds decision. It was just that we had a participant who was involved in these cases, and they said that in their experience it actually depended on the type of court that was being used. So youth courts, in their experience, were very much adhering to this policy, this idea that we have to wait for the conclusive grounds decision. There is no ifs and buts about it. But they were suggesting that in the Crown Court in England and Wales, they would sometimes set a date for an adjournment. They would say, all right, well, if we don't have it by X date, we're proceeding without it. Without the decision. And that goes against what we were told is official policy by CPS, and I guess that might just be an English and Welsh problem. I don't know if it's happening in Scotland as well. But certainly there was some pushback there. So that's potentially really problematic if we're supposed to be waiting for these decisions. These decisions are supposed to be instructive for prosecutors in terms of their decision making. And if nevertheless courts are going ahead or forcing the hand of prosecutors to proceed without these decisions, that's potentially a ground of real concern.
Okay, and if a conclusive grounds decision comes back, does the court have to accept that decision, or can it disagree and say that actually the CG decision says that they are a victim, but we don't think they are? Yeah,
absolutely. These conclusive grounds decisions are not as conclusive as the name would suggest. So they, in fact, as I've said, they are instructive, but we were told by participants that they are prosecutors can only deviate from a positive conclusive grounds decision where there's good cause, there's good reason, and that corresponds to the Palermo Protocol, which has a definition of trafficking and what trafficking in persons means. So perhaps what's slightly unclear, is what would happen if the victim's story is very much one of trafficking, i.e. it corresponds with the Palermo Protocol, but the prosecutors, for whatever reason, perhaps don't think that the story, based on the evidence they've gathered, is credible. Maybe they don't believe the credibility or the reliability of the defendant, of the suspect. Because this is something that happens all the time in other realms of the criminal law when we're dealing with evidence and process. Quite often it's precisely because they disbelieve the story of the suspect that they push towards, that they end up prosecuting, and that must happen in situations of human trafficking as well. So it's an interesting point there, that I'm not quite sure the extent to which these conclusive grounds decisions, but on paper they're supposed to be quite important. What we do know, at least in England and Wales, however, is that these decisions are not available as evidence in where cases do go to trial, and
what
a
does that
victim
mean?
Does want to.
Again, as not a lawyer, what does it mean? Not as evidence?
So if a victim were to rely, an alleged victim of human slavery were to rely on the Section 45 defence, precisely because the CPS have decided, we think that either there's a public interest or we disbelieve, I suppose, that, let's just say, the lack of public interest, because we're not quite sure about that second element there. If they were to rely on that Section 45 defence, they would not be able to use a positive conclusive grounds decision in evidence. There's a case from 2021, I think, and maybe that's the case report, around 2020, 2021, called Barclay, where this was an issue in question. Can you use this conclusive grounds decision from the single competent authority?
And they're the people that make
make the decisions under the national referral mechanism. Can you use these decisions to bolster your claim for that you have been trafficked?
And that case said no.
And that case said no, you can't. Essentially, it was quite a damning indictment about the reliability of these conclusive grounds decisions. Because what they said there was that we have this system for determining when expert evidence or skilled witness evidence is the terminology it's often used in Scotland, when that can be introduced in court, when it will be admissible. And usually it revolves around factors such as necessity in the first place. Do we actually need this evidence in order to make a determination? And are the credentials of the issuing of the expert, are they sound? Is it a reliable a body of work? Is it a reliable scientific background for the evidence as well? And they essentially said that conclusive grounds decisions don't meet the strict criteria for admissibility of expert evidence.
And that was because in this case they found that the single competent authority didn't have as much information as the prosecutors had. The prosecutors actually had more information about this defendant than the single competent authority had, so the conclusive grounds decision wasn't based on the full picture.
Exactly.
So what I'm getting from this then is that the conclusive grounds decision is an indicator as to whether somebody should be understood as a victim or not, but it's still, the court can still decide whether to agree with that decision or not. Is that right?
That's exactly right. That's exactly right. They are, I suppose, illustrative, useful, but they are not. They may even in fact be necessary in the sense that they need to exist before prosecution go ahead, but they're not sufficient for a decision. They can be deviated from, and in fact what we know from practice is that they often are deviated from.
Okay, so coming to the crux of the issue then, we've heard about how England and Wales applies the defence, and we've heard about how Scotland doesn't have the same defence available, but that it does account for those situations. So, do you think that Scotland should have a defence?
Yeah, so this, I suppose, full disclosure here, I came to this having just written a paper about the fact that Scotland didn't have a defence, and I was slightly concerned about this because I don't think that the common law defences of coercion and indeed necessity is very similar, but it doesn't require a person threatening you to do X, or else they will hurt you. But these common law defences are very narrow, and as I said before, they require an immediate threat of death or serious injury in order to apply, and that's just not how we understand trafficking situations in terms of how how victims of trafficking come to be held within the thrall of their captors, so to speak. So I was coming at this with a point of view that there perhaps should be a defence. I think that the Lord Advocate's instructions are great. They've done a great job, but a belt and braces approach is perhaps necessary here.
And I was similarly surprised when I was doing all the research on the Section 45 defence in the Modern Slavery Act to learn that there wasn't something like this in Scotland. But then coming from the workshop and all the discussions we had, I'm not sure that it's clear that we're saying that Scotland should have a defence. Yeah,
it's really funny you bring that up because, in fact, I distinctly remember one of the participants talking about it. They might not quite have used the term barbaric, but they certainly thought that it was regressive that when they found out that Scotland didn't have a defence.
But I think by the end of the workshop, we'd all kind of changed our minds on that stance.
Oh, absolutely. I think that was their point, was that, when it was introduced in 2015, that was their point of view. But over the last 10 years, they've really become less enamoured or jaded with the Section 45 defence in terms of how it's been used.
And we really don't know a lot about that either, because there's no quantitative data at all collected on the Section 45 defence, so we don't know how often it's been used, how it's been successful, who's used it. We just don't really know a lot about it, other than anecdotal.
Crazy.
So in terms of Scotland then, if we're saying from the workshop that it wasn't determined that we're saying they should have a defence, that must mean there's already some really good practice coming out of Scotland. So can you tell us something about that?
Yeah, absolutely can. So I think one of the resounding or sort of the majority views of the workshop was that the situation in Scotland was perhaps preferable to the situation in England and Wales, precisely because what had emerged over the last 10 years was a culture of, to use sort of, if I can talk about different types of legal process for just a second, bear with me. We talk about the difference often between inquisitorial and adversarial style systems. And in inquisitorial style systems, generally across Europe, for example, there is more of an emphasis on institutional actors working together to try and discover or determine the sort of truth of the matter, so to speak. And to that end, you'll have a judge as a principal investigator, and they're working with criminal justice actors to reach a conclusion. Whereas adversarial style systems like Anglo-American jurisdictions, so like Scotland, generally speaking, England and Wales, that's where the parties sort of lead the narrative. So the prosecutor comes in and accuses the defendant of having committed a crime, and the defendant says, no, I didn't, and here's the evidence of why I didn't. And what we saw from the workshop was that there was this, despite it very much still being an adversarial legal system, Scotland had, through the Lord Advocate's instructions, had created a situation where there was much more of an emphasis being placed on determining liability, criminal liability, before a prosecution, before a trial ever took place. And that has a distinct advantage in that it prevents potential re-traumatization from happening for victims of trafficking who have potentially just gone through some quite harrowing experiences, to then be subjected to the criminal justice process itself, which is deeply traumatizing for often for defendants and victims alike. And so for that reason, the Scottish approach was perhaps preferred, because in contrast, what we discovered and what we were learning from our participants is that because of the existence of the defence, there was a feeling among some of the participants that there was a propensity to move towards trial, because that was ultimately the venue, the appropriate forum to determine criminal liability. You know, this, to put it colloquially, let's just go to trial and let's see what happens. Let's see if the jury prefers the defence. Let's see if they prefer the line of the prosecution. So there was, albeit despite the fact that the official process, there is this 4-stage test to prosecution for CPS in England and Wales, and they do consider whether or not there are circumstances of modern slavery. They do consider the availability of common law defence of duress, of the statutory defence under Section 45. Ultimately, it seemed as though more cases were going to trial, that participants were talking about there being, to them, what they viewed as quite clear evidence of trafficking of modern slavery that was being minimised or perhaps not appropriately reflected in prosecutorial decision making, and leading to a situation where the presence of a defence was encouraging a more adversarial approach to this idea of liability for victims of trafficking.
And one of the things that came up that I really remember distinctly as something that is offered in Scotland is that they had a memorandum of understanding with some non-governmental organisations that when a victim of human trafficking has served prison time and has been in custody, on release they have this agreement that there will be somewhere safe for this person to stay to prevent them just falling straight back into the hands of the traffickers. And that seemed like something that almost stopped everybody in their tracks to say, that's such good practice. And thinking about those things and the vulnerabilities that exist for people once they come out of the criminal justice system is so important to think about, not just the vulnerabilities at the beginning when we're thinking about whether they're going to enter the criminal justice system.
Yeah, you're absolutely right. And I would just clarify, I'm not 100% sure on this, but I'm fairly sure it's not just if they've actually been convicted, but also just at that preliminary stage when they're thinking about prosecution as well. And it's and they can get in touch. There's based out of Glasgow, there's Tara, and there's also Migrant Help as well. I think those are some of the NGOs that they're working alongside the COPFS and Police Scotland to help these individuals. But you're absolutely right. It's a really good practice.
So while we've heard some of the benefits that the Scottish approach has, would you say there are any limitations into the way that the workshop run that might mean we've got to consider how accurate that is in reflecting practice?
Yeah, absolutely. So I think if I can, sort of talk about this in terms of being a bonus or a plus and a negative, I would draw attention to the fact that one of the other interesting findings from the workshop was the relationship or the comparative relationships between police and prosecutors in Scotland and England and Wales. Yeah. So what we learned that was quite different about these two jurisdictions is that whereas in England and Wales, the police, you have various constabularies and they work alongside CPS in different regions. In Scotland, since the introduction of Police Scotland as a unified force, you have this unitary response in Scotland where Police Scotland are coordinating with COPFS in Scotland, and COPFS are actually able to instruct Police Scotland to carry out further investigations.
So there's just one police force in Scotland?
Yeah, that's exactly right.
Okay.
There's just one police force, obviously with regional branches, but there is very much, it's a unified response in terms of policing and how policing is carried out in Scotland.
Okay.
And that relationship with COPFS, as I say, is much closer. And we were told by participants that COPFS can go back and say, hey, we're worried about this potential issue of trafficking here. Can you go and, carry out X investigation, or try and find further evidence here, or ask these certain types of questions. And of course that's very good. What we were being told by participants is that this is a particularly a good form of practice. But what it also meant, and this really gets the crux of your question about potential limitations of our research, is the fact that there was, just as there's a a unified force in Scotland working alongside COPFS, it was kind of a unified response that we were often getting from those participants.
Yeah.
And we were unfortunately unable to secure on the day representation from criminal defence in Scotland. And so I would say that there is a potential for there to have been a slightly more favourable impression given of the Scottish approach than was given of the approach in England and Wales. That may not be the case. It may just well be the case that, if you take our information at face value, there are primarily lessons to be learned from Scotland by England and Wales. But I would probably think, I think this is definitely, there is scope for further research here, and I think because of the size of the jurisdictions, the relative size of the jurisdictions, it's much harder to find people who are specialising in this particular type of case in Scotland.
So this brings me to asking about some key takeaways for us to think about off the back of the workshop. And one thing you've said there is how important it is to have multi-agency collaboration.
Absolutely.
Was there anything else that you think was really important that came out of the workshop?
Yeah, I think there are a couple of related issues that were really eye-opening for us coming out of that workshop, and you can obviously jump in here as well. I'd love to hear your own personal reflections. But for me, I think that there were real potential issues around knowledge gaps.
Okay.
And I think that what we, related to what I've just been talking about multi-agency collaborations, that institutional cooperation between COPFS on the one hand and Police Scotland on the other, is that you are seeing less of a knowledge gap, so to speak. But we were told by participants there are still issues in relation to police training, for example. So, if you have a new officer, only very recently have they introduced bespoke training on matters of human trafficking and exploitation in Scotland. So there will still be a number of officers out there who are perhaps old enough in the job to have missed that bespoke training, but young enough in the job to have never experienced modern slavery and human trafficking in their own practice and their own work, and who perhaps don't know the types of questions they should be asking, the types of investigation that they should be conducting. And so there are still definitely gaps in knowledge there. But as I say, this is perhaps somewhat mitigated by the fact that COPFS can turn around and say, did you ask them about this?
Yeah.
Did you look for any evidence of this? And that could be quite helpful. It seems like there is more of a chance for these knowledge gaps to present uneven experiences for victims of trafficking in England and Wales. I don't know if that's what you took from that as well.
Yeah, I did, and I don't think it's unique to this conversation about the statutory defence either. And when we think about how many different offences that police and lawyers have to deal with, it is totally understandable that not every police officer knows absolutely everything about absolutely every offence. How could that possibly happen? But we do have to think about what we can do to improve knowledge for those who are most likely to come across victims. And it is something that comes out of nearly every report into modern slavery and human trafficking, that we need more resources and we need more training. But that's not always a helpful recommendation. If we know there aren't resources, how can we get around it? And when it comes to training, we need to think about specifically who needs the training and what is the training that they need. But from this workshop, it really seemed like we need to encourage this professional curiosity in those conversations between police and prosecutors to make sure that when people are presenting and we're understanding them as offenders, that we do start to question the experiences that they had and consider whether they were victimised into committing those offences, so that we do uphold our international legal obligations in providing for not punishing people who were victims and committed offences as a direct result or because of compulsion of their modern slavery or human trafficking experiences.
You're absolutely right. And I think the other thing I would add to that is what emerges from what you're saying is that we came in, or at least I came in with the curiosity. We both came in with the curiosity of Scotland doesn't have this defence. Ought it to have this defence? And I suppose what we've come away thinking is, well, perhaps not. Perhaps the law on the books, the procedure on the books is fine, but what actually needs closer attention is how we go about implementing that procedure on the ground in terms of at an individual level rather than at the institutional level at times.
Yeah.
And I think related to what we've been discussing, and one more important point is that, you know, it's about people at an individual level, understanding about modern slavery and human trafficking, what it is, how it can manifest, and that there's not a one-size-fits-all approach.
Yeah, absolutely. There's so many different experiences.
Yeah, absolutely. And one of the disheartening things that we took away from the proceedings is that, you know, biases still exist. You know, one participant told us that they'd had a case where a person was pleading Section 45 or made their intentions to plead Section 45 clear, and the judge said something along the lines of, "Oh, really? You're too old to be pleading that defence." So there's this understanding or lack of understanding still amongst professionals, you know, about modern slavery, who is affected by modern slavery. You know, that there isn't just a cut-off date where all of a sudden now you have agency, you have autonomy, and you can and should know better. You should be able to get yourself out of that situation, which is, that's so clearly. As is always the case with these things, education is one of the key issues.
Yeah, and we did talk about those age differentials and the impact of age on understandings and responses in the workshop as well. But there's so much more that we did talk about that we can't cover here. So if anyone did want to read the full summary of the workshop proceedings, that is available, and we'll share it as a link along with the podcast. And if anybody wants to get in touch and talk about anything that we've discussed here, you can reach out to us both. Dr. Grant Barclay, Dr. Alicia Hayes, and our contact details are available here with the podcast as well. So thanks very much, Grant. I feel like I've learned so much from doing this piece of work with you.
The feeling is mutual. Thank you so much.